Hello and happy Monday to all. My name is Kyle Sebastian and I am the Jed Campus Learning Community Coordinator at the Jed Foundation. Jed is a nonprofit that protects emotional health and prevents suicide for our nation's teens and young adults. Through our signature program, Jed Campus, we partner with nearly 300 colleges and universities across the United States to guide them in a 4-year collaborative process of comprehensive systems, program, and policy development that builds upon existing student mental health, substance use, and suicide prevention efforts on campus. Today, we would like to welcome you to the second of our two-part webinar series surrounding student mental health and the law, which is a resource that Jed developed over a decade ago that discusses legal issues that colleges and universities face while addressing campus mental health and working with students in distress. We are once again joined by Peter Lake, Professor of Law, Charles A. Dana Chair and Director of the Center for Excellence in Higher Education Law and Policy at the Stetson University College of Law, as well as Dr. Victor Schwartz, who is the Chief Medical Officer at the Jed Foundation. Before we launch into some housekeeping notes and the rest of today's webinar, we'd like to open with a reflection. As some of you may know, this September we lost our friend and colleague, Dr. Gregory Eels, who is the former Director of Counseling and Psychological Services at the University of Pennsylvania, as well as a longtime Executive Director of Counseling and Psychological Services at Cornell University, as well as a national leader in campus mental health. Prior to his passing, Greg was poised to present this webinar with Peter in October. And though we miss his expertise today, we more importantly reflect upon and celebrate his friendship, while reminding ourselves that we too, as professionals, are not alone and can reach out for help when needed. We want to meet the needs of our students and ensure that we also take care of and sustain ourselves and each other in our work. So as we continue today in discussing the legal principles that surround our work in protecting campus mental health, we hope that you will join us in a campus-wide approach to promoting student mental health that exists to support everyone at the college and university. As we move on to some housekeeping items, I want to direct everyone to the closed captioning services link that you can use from the welcome message as you logged on today. Second, if at any point you have a question for Peter or Dr. Vic, please type it into the question box on your dashboard, which we will answer during our live Q&A during today's webinar. Third, you can find a PowerPoint version of today's slides in the handout section of your dashboard, as well as a PDF version of Student Mental Health and the Law. If you do not choose to download the handouts during the webinar, or you are eventually listening to a recording of this presentation, you can simply ask for a copy of these files by emailing me at kyle@jedfoundation.org. For those unable to join this webinar, it will be recorded for access through Jed's online mental health resource center. And finally, we want to remind everyone that the information provided in this webinar is not intended to be a substitute for or to be relied upon as medical advice, diagnosis, or treatment, nor is it intended to be a substitute for or to be relied upon as legal advice or counsel. This webinar is being presented for informational purposes only. In review, Student Mental Health and the Law, a resource for institutions of higher education, was originally published by the Jed Foundation in 2008 as a tool to aid institutions of higher education in developing awareness of various issues and concerns relating to campus mental health and working with students in distress. In part one of the series, we discussed how Jed's recommendations have had an impact on some of the legal cases surrounding campus mental health law over the last decade, with an emphasis on how institutional practices can be shaped to make college safer and more responsive to the mental health needs of our students. We framed our discussion around the 4 main sections discussed in the document, including privacy and confidentiality, disability law, delivering mental health services, and liability for student suicide and violence. Today, we're going to continue the conversation by addressing the legal implications surrounding these topic areas through the questions that were submitted by the live audience of our Part 1 webinar. As a reminder, if you were unable to view that part of the series, you can find a copy in our Mental Health Resource Center. As both Peter and Dr. Vic discuss the previously submitted questions, please submit new questions using the GoToWebinar question box. Throughout today's discussion, we hope that you will learn more about the key principles and recommendations that colleges and universities should consider in developing policies and protocols that promote the mental health of students on campus. We will also dive deeper into some of the 14 quote-unquote good practices mentioned in the original Student Mental Health and the Law resource, and we will also help colleges and universities think through application of these practices while considering the unique characteristics of their own institutions. And with all of that, I want to once again thank Peter and Dr. Vic for joining me today, and I'm going to go ahead and pass things off to them.
Thanks, Kyle.
Thanks, Kyle.
This is Vic Schwartz, and I just wanted to a little bit comment on Kyle's comments before. I feel in both sad that I'm here in this role because this originally was supposed to be the role Greg was to have played in the second section of this webinar series. And at the same time, of course, I always actually love speaking with Peter, and I find these topics very, very interesting. So, I'm glad that I'm able to join you for this conversation and question and answer period. But it is unfortunately tinged with just a touch of sadness. But I think, as Kyle said, it really raises for us the importance of recognizing the importance of our own self-care and, turning to support colleagues, friends, family when we're in need.
Yeah, Vic, I've got to say, this is Peter chiming in, and thanks, Kyle, for your thoughts too. That I don't really think I could do this today if it weren't for you, Vic. I'm kind of leaning on you emotionally more. I think you might realize this is the most emotional webinar I've ever done, very personal. And I agree with everything you said. I knew Greg well enough to know that he would want our work to continue and to go forward. And I'd like to believe that among the things that we can take away from this very unexpected experience that we've had, that we are not helping robots. The people who are out there doing this work are humans. We're vulnerable. We experience many of the things that we're involved in, and people should always try to remember that. I think the narrative in higher ed sometimes is very unrealistic and invective, sometimes bordering on defamatory. It takes a toll on the people that do this work, and I think this is a moment to pause. It also is a reminder that no matter how good we get at this work, we'll never be perfect at it. And so it's something that needs persistence and permanent attention, that nothing is entirely 100% preventable. And those are takeaways. I miss them dearly, but Vic, thank you for being here today, because I'm going to lean on you pretty heavily if you don't mind.
Okay, absolutely. I guess we'll lean on each other, because I looked at a couple of the questions and I said, I hope Peter has some ideas about some of these. So let's see how things go.
Sure. Well, the first one, Vic, is, are all higher ed institutions required by law to have a counseling center? And I've been to so many depositions and hearings that, my tendency is to say no, simple no, because no, there's not a singular mandate to have counseling centers for all higher ed institutions, no particular requirement. But on the other hand, there are campuses that have undertaken to provide certain services to students, and by doing so may have continuing obligations to persist with that. There's also, and I think this comes out of the last webinar that we did, that it is not a specific mandate to have a counseling center, but it is becoming increasingly unrealistic to think that reasonable care on campus, if it's required, wouldn't require that we either have a center or have some kind of arrangement for access to services as best we can. For the really small institutions out there that simply do not have the space, money, resources to provide counseling centers, one of the things people are doing, and we've been encouraging this from the beginning, is to work on consortium and outsource basis, and to do what you reasonably can with the resources that you have. And I suppose that's the easier answer here, Vic, is to say that I think the law is moving towards encouraging people to do what they can to provide reasonable services. And in some situations and on larger campuses, that almost implies having some kind of counseling center. It's almost impossible not to have that, but the field is so vast and so varied in its resources and situation that there's no single mandate, legal mandate to have a so-called counseling center.
So Peter, I agree with you completely, and I'm just going to follow up with the implicit part B of this question, because I, from time to time, actually heard then a variation on this theme that if there's no requirement and if there's liability for, doing it incorrectly or improperly, maybe it would be, from a liability perspective, safer simply not to have the service. And as I've said, in response to that, well, students might actually get food poisoning in your cafeteria, but I don't know that that would lead you to shut down all of your food services, because, like having a cafeteria or food services on campus, I think this is becoming a kind of given from certainly residential campuses, that it's simply part of the structure of services that ought to be there because it's the right and sensible thing to do. That said, many community colleges or primarily commuter schools have very, very different structures for their provision of mental health services, because, in those situations, students often aren't looking to their college to provide basic human services on campus. But, there should be some way of getting people help when they need it.
Here, Vic, and I think if I'm sitting as a lawyer with a campus and they say, do I have to have a counseling center? I back the conversation up to the business realities that particularly with Gen Z students and some residual millennials, you see overwhelming demand for supportive services, including counseling centers. And so you probably aren't going to have much of a business left if you have no interest in this topic with your consumers. They will start moving to other institutions and drifting away and not succeeding. And it's not a business reality. And then Vic, you and I have talked about this assumed duty thing for years. And this is one of the things that comes out of that Massachusetts case, the Wynn case we talked about last time, is if courts believe that we have a special relationship with our students, then the issue of assumed duty is a dead letter issue. We have responsibility. Now the question is doing what's reasonable. And I don't want to provide knowingly inadequate services. That would be risky and unreasonable. But we don't refrain from doing something simply because there's the possibility that occasionally something goes wrong. Any more than you'd never leave your house because there's a risk of a car crash. We have to drive, we have to transport. It's part of life. And here today, I think one big message last time, Vic, is that we live in a world where our students, the disabled and the non-disabled, are demanding supportive services, including counseling of all varieties. And they aren't going to stay in school and make it in school without these support services. And so business has changed, and in part because we opened the door to our businesses to a much wider group of people who've been closed out before, who needed those services, but could never get them.
So this is all part of a good thing, actually, to make sure that we have those services. If we're accepting students who might have these needs, it seems counterproductive and potentially foolish not to create a context for them to be able to thrive in. So when you think again about the cost of losing students to leaves of absence, or choosing other schools, the economics of providing good services makes sense as well.
Sure. So, and Vic, I know it's just the first slide, but you may have recalled this fall there was a brief discussion that was quite intense for a while about red flagging of admissions files. And one of the things we're seeing now, and I don't know that the public is generally aware of this, that when you sit and read an admissions file, if you read 100 of these things, you're going to read about suicide attempts, cutting, or self-harming behavior. Many of these things are in the past and are part of a descriptive or narrative, a lived story that someone tells. But in some cases, you're actually reading something that's pretty scary. And just on a human level, it's inconceivable that people who care about other human beings are going to read something like this and just toss it aside and say, well, we're not admitting that person, so
Right.
we don't really need to worry about it. It just isn't, humans aren't going to behave like that, particularly in higher ed.
Right. We hope not. Right.
No.
Okay.
Okay, Peter and Vic, we're going to move on to confidentiality. And so we had two statement questions that arose from last part. So as a clinician and as we form a threat assessment team, I understand I can be a great listener without saying anything, but I am concerned moving forward about information that I would like to share but cannot. And then issues with the importance of confidentiality have repeatedly raised their ugly heads and been a point of contention, particularly in relation to non-clinicians and administrators as related to the BIT. So what suggestions do you have for addressing the importance and difficulty of confidentiality when participating as a clinician on a BIT-TAT care team?
Well, Peter, if you're okay, I'll take a try at the first round of this because I'm assuming that the writer was writing as a clinician. And just want to make a couple of simple framing comments about this, which are that clinicians sitting on the BIT team obviously are completely in a position to listen to any incoming information. So confidentiality relating to clinical information the clinician might have, the counselor might have, who's sitting on this team, isn't an issue in terms of receiving or hearing information while sitting on the team. That goes for, speaking to family members who have a concern about someone as well, or administrators. Therapists, counselors, clinicians can hear information even in a setting where they can't necessarily share it. So there's valuable role to be played by a person from the counseling service in terms of providing advice, providing general direction about the management of a situation that can be provided without really tipping your hand as to whether or not that student may or may not be getting care at the counseling service. So that role is absolutely not a problem. Where sometimes this gets a little bit tricky is a student maybe who the counseling service knows about, who's come to the attention of other people, and there's a question about whether or not to make an administrative referral for an assessment at the counseling service. I think there's a range of possible ways of handling that might not, where you can provide some vague information which is helpful without necessarily running afoul of patient confidentiality. So if the counseling service director, in the face of a question about should a student be referred over to counseling, might say, that might not be necessary under the current conditions. And so I don't believe, and you might have a different sense of this, that would be running afoul of confidentiality to make that kind of comment. Also, it's just important to put out there that depending on how notes are taken and what the status of those notes are, but FERPA does not in any way limit, and put aside clinicians for a minute, but FERPA does not in any way limit people sharing behavioral observations or observations about a student. So there's plenty of latitude for people to speak with each other in a BIT team setting. Again, that might change depending on how those notes are used. So I'm going to now stop and let you tell me what I said that was wrong.
No, it's all dead on, Vic, and you're just a permanent font of wisdom here. You've always intuitively understood the law as it should apply in practice, and I've always really enjoyed that working with you. You know what I noticed, Vic? I noticed that a lot of folks don't understand the boundaries that clinicians have. They think they do, but they may not really understand it. And therefore, there's sort of an unending need to train people on what the legal boundaries are for required disclosures, but more importantly, the thing that I find is very difficult to get across to people is the professionalism dimension of this. That very often the sharing of information or the use of information exists in a space that isn't necessarily do or don't, but rests very deeply with professional instincts of people with lots of experience. And that's very difficult to train people on. They have to work with professionals to understand that, I could or I might not be able to do this, but I have professionalism issues that impact my thinking about what I want to do and who I want to be as a professional. The other thing that comes up, Vic, a lot is a lot of nonverbal communication that goes on. And I've actually seen this in teams where someone, sort of looks at someone to see if they react. And,
Mm-hmm.
and it is possible to be put on the spot with nonverbal communication, which actually is a big part of the teams, especially when people work a lot together. It's like submarine duty. And
Yes.
you can tell a lot by someone's body positioning sometimes if they know something or they don't. And I think that itself creates a lot of issues for the team. I see misunderstandings about FERPA and how it relates to medical privacy law. That still comes up, and I think people have some, again, can always have more training on those boundaries so they understand where that is. And I think the other thing, Vic, is that I think sometimes the clinicians may not realize just how much we want to learn from the clinicians. We want to know how you think and what you know. And one of the mistakes we make, like a lot of learners, is we try to learn situationally as opposed to learn abstractly. And so it's when something situational occurs, we start trying to press clinicians to teach us what they know, but then we're walking into territory that puts the clinician in an impossible position of either not telling us anything at all or telling us something and risking some kind of boundary crossing, whether it's professional or otherwise. And probably the last thing, just a reminder to the rest of the team, is that if you start pushing your clinicians to share confidential information, then you've essentially turned your team into a healthcare providing unit. And that subjects potential responsibility for medical negligence issues. And so what you always want to be careful of is that non-clinicians don't transform into pseudo-clinicians and get treated legally that way. And that I think actually was, I don't think it happened at MIT, but years ago with the Shim case, that was, I think, one of the allegations that was made that never really got tested in court fully was, did a team start operating like a medical health provision unit because the clinician side was dominating the dialogue? And again, if someone perceives that, then you step into some pretty dangerous territory.
Right.
So.
And, this is where you nicely led me into one of my favorite, in training meetings with people on BIT teams, and I've used this over the years with people in residence life and student affairs, that, it's very important to remember the great sage advice of that philosopher, The Rock, who says, know your role. Right. So you need to, right. You're right that I think people sometimes, and it's typically driven by a real desire to be helpful and to, really use the process to move things along and to help students and to help the system. But you need to have a healthy respect for your limitations and what you can and can't do. But that said, the teams have a lot of space to work in, and really shouldn't run afoul of patient confidentiality. That shouldn't really have to come up. In a situation where there's really a kind of serious, imminent, dire emergency, excuse me, you have a tremendous amount of latitude, and otherwise you have enough space to operate typically.
Here.
Yeah. So I guess we can move along so that people.
We're going to go to the next clump of questions regarding confidentiality. So if it is the policy of student affairs that a counseling center staff inform student affairs wherein there's duty to warn, what are the ethical limitations to following the policy? And then a major issue in the sharing of confidential mental health records with general health care center staff. Could you address the protections that should attend mental health records?
Well, these are two very, very different questions, but they both have to do with how information gets from student affairs or a bit team or housing or something like that from the counseling center. So I would actually, in the first question, take exception to that policy. I'm not sure that a tripwire policy that says if a student is in a crisis where it would require getting other entities involved, that you necessarily have the latitude to, or that you can obligate the the counseling service to engage student affairs. Now, you probably typically would, but I could certainly imagine circumstances where that might not be either sensible or necessary. So just as a quick example, if the counseling service hears from a student who is across the country during the summer break, who's having some kind of specific crisis, where there may be very good reason to engage that student's family with whom the student is currently living, I don't know that it necessarily is either legally or from a policy standard okay to just, again, as a matter of course, say we're going to let student affairs know about that. So I'd be curious to hear your thoughts about that first situation, Peter.
Sure, Vic. And again, the lawyer hat jumps in here, and I can't give legal advice, but I can frame this so that people could seek the opinion letter they might need for this sort of thing. And there really are two dimensions to this. One is that state law is very specific in many cases about the clinician's obligation to warn or otherwise take reasonable care to protect someone in imminent risk. And you have to be really aware of the specific parameters of the state law that you're in, because there are statutes and court cases that vary a little bit in what they say. And it could actually be the case that a warning given to someone other than whom it is reasonably appropriate to give it to or statutorily required could actually violate state law. And there may be ethical limitations. And this is my point from before, because I think there could not only be professional standards that are at risk, but also professionalism standards that come into play in informing someone other than whom the clinician directs the attention. And I'll just say, instinctively as a lawyer, if I'm in a deposition and a clinician tells me, under a confidence order, that I really felt that the only people that should have known this were the parents, not everyone else, that kind of a statement's going to get weaponized against a policy like this somehow. And so it doesn't mean that you don't do it, but I think the people that have this kind of system, I think you need an opinion letter from counsel that basically addresses the legal standard in the state and also the minimum professional requirements and professionalism standards that are implicated by having a policy of this type. It also would benefit from a focus group with bid teams and others to talk through some of the issues that they've experienced. Doesn't mean you don't do it, but I'm a little concerned that there are potentially wrinkles with this, particularly in certain states and under certain circumstances.
Yeah, I think there is a concern along those lines because, again, in most states, I think you can breach confidentiality, but with the narrowest group of people necessary in order to take care of the emergency. And I think this is one of these situations where tripwire policies, where, if A happens, you must do B. You need to be really, really careful about those because, once you can start to think of situations where that might not apply, this policy has painted you into a little bit of an institutional corner. Maybe we should, what about thoughts about shared records between counseling and health services? I would say in my experience over the last 25 years or so, there's certainly been a move to administratively connect health and counseling services more and more, partly because there are economies of scale. So it often administratively and economically makes sense to look for areas where some activities that can appropriately be joined are joined. I would guess, in my experience, and I don't know if you have the similar experience, that records and appointment systems, even if they share the same platform, are kept separate from each other. And although that said, I would say that there might be circumstances in which it would make sense to have an emergency, breakable window, so that if a student comes in, with an overdose or is found on campus and winds up at the health service, where it might be useful to have a capacity for the director of the health service or something to be able to, with special administrative approval, get through into the counseling service information. But curious to hear your thoughts and experience about this.
Yeah, I mean, Vic, this could literally be a webinar into itself in terms of discussion. I'm trying to think about how to answer this without going too far or just ducking the question. But here's what I'll say, and I think, again, you intuitively hit the nail on the head, that during the recession, I think just purely in some cases for economy of scale, you started seeing more combination record keeping and central management. And again, you can train people to manage healthcare data with appropriate levels of confidentiality. But this is where I think a business challenge is potentially going to burgeon into an actual legal problem if we're not careful. And here's the thing that I've heard people complain about is that, well, I go to my counselor and I share some stuff, and the next thing I know, all of my information has gone to this big operations unit that's crunching my data on platforms with other data. And I kind of feel like I'm losing control of what I think of as a confidential relationship with my counselor in the counseling center. I just don't necessarily feel like broadcasting everything that I'm doing to a much larger and potentially unknown population. And that sharing might well be legal and may well be within the boundaries of, if people are properly trained, of current legal standards. But I see a business problem here, that the consumer comes to a unit with this expectation, reasonable or not, that data will be shared in a certain small circle of people, and next thing it's not. The other thing that comes up is physical locality seems to matter a lot as well. So that if your location of your counseling service is sort of proximate to other healthcare areas, you start getting observed coming in and out of that system. And then you start wondering, am I really getting the confidential experience that I want? One way that some schools are coping with this, I know you know this, Vic, is they make house calls. If they can't find a space where people won't be observed, they'll actually go to the student's room themselves to meet with them, or some other location. And I'm seeing people proxy around what is a business problem that has a potential to become a privacy issue legally in some ways. So I could do more and more on this, but I think those are the comments I'd like to make for now.
Yeah, and I'll just make one comment about the location. That what you're suggesting in terms of the co-location of the counseling and health service can actually cut both ways, because if there's a single entrance, then people don't know if you're going to get your leg checked out or going to the counseling service. So there's a potential advantage, although, obviously at some point, I think almost every service is going to have separate offices for, for the counseling service and the health service. I think everybody's dependent on the notion that, anybody who's waiting at the counseling service is in the same boat. So, there's no way of maintaining perfect privacy short of what you said of, seeing people locally making house calls. But, the logistics of that are pretty challenging. And not so easy to handle, right? Yeah. The one other thing I'll say about records is, it's important, no matter what the structure is, to make sure that in your, when students come in and sign whatever kinds of admission paperwork, talking about getting care, that you're explicit and clear to them. And I know everybody's thinking, but nobody ever reads any of that stuff. But at least you should make sure that those things are laid out there explicitly, so that there are no obvious surprises. The other thing I'll say is that for places that do have some capacity of sharing records. So, if there's a pharmacy, or there might be, in some places, a medication record that's shared, which, there are arguments why that makes sense in terms of safety and drug interactions. You should make sure the student's aware of that. But you should also make sure, if people can get access to the records, that you stick to the really sort of specific clinical information and not use the charts or the records as a place for what in the old days we used to call process notes. So you don't include the very personal disclosures that people have made potentially about, their past history, which, are relevant to their treatment in a broad sense, but, wouldn't be really necessary for somebody who needs to be managing a student with panic disorder on the medical side, right? So you shouldn't be including those kinds of things where there's any capacity for sharing of records with people outside the counseling service.
Okay, so we're going to go ahead and move on, and last time we discussed advanced directives, and rather than reading the question, I'll put it out there, and let's see if we can go into this a little bit more.
Well, so again, I'll make a couple of comments, and people might want to look at the Jed Foundation Set2Go website, set2go.org, where we have an example of an advanced directive that we did with NAMI. It's basically a kind of release of information. But it's a release of information that you do not, at the point where you've started treatment, but as a kind of planning tool. So in that sense, it's really the same thing. It's just being used in a slightly different timing and context. The student has the right to rescind it at any point, but it does, if a student's incapacitated for medical or psychiatric reasons, at least it gives some information about, what can and should be shared with whom, and where it lives. Typically, I think in most cases, it would live in the counseling service, because they would presumably be the ones to respond to a psychiatric emergency. But if a student is using it for a medical problem, a student, let's say, who has unstable diabetes, for example, might want to do something like this with, with the health service as well. So this is a situation that could apply equally on the physical health side as on the mental health side.
And Vic, I don't have a lot to add here, but just a quick point about where medical privacy and FERPA may potentially deviate from each other. And any kind of advanced directive situation, to the extent that we're trying to get prophylactic FERPA releases, that is something under some circumstances, there have been some concerns about blanket waivers or non-specific releases of student education records. Now, again, medical records are exempted, so those could be shared on a medical privacy basis, but there could be a temptation to also share non-medically private information that would qualify as an education record. And to that extent, I wish FERPA were more specific and helpful on this, because we don't really have an advanced directive culture with FERPA, even though we probably should. But it is something institutions would want to think about. Probably the simple way to deal with this is just to make sure that advanced directives really do specifically relate to medically appropriate information.
Right, and I think in a situation where a family and a student is saying, well, the parents want to get the report cards,
Yes.
We're probably dealing with a different kind of problem.
Yes,
and that, that's taken up, I think, in a different webinar.
Yeah. Well, in fact, this exact sort of thing happens. It's like, oh my gosh, my student's in the hospital. How's she doing in school? She's showing up for class. Right. I mean, the parents approach this holistically. They don't break things into the silos that we think in, and they'll get extremely frustrated when we don't provide what they would think would be obvious and simple information. And
by the way, that might be a legitimate question, because if somebody's been depressed for the last 6 weeks, it's a distinct possibility that they really haven't been functioning. But at the point that it's a serious enough problem to require either a hospitalization or a leave of absence,
Right.
it should simply be discussed with the student.
Yes.
And if they're not agreeing to share that information, then again, you have a kind of therapeutic challenge that needs to be managed.
Exactly.
I think we want to move on to the next section so that we leave at least a couple of minutes for, the questions from this hour.
Okay, so we're going to skip a couple, and as a reminder, you can put in questions into the box to answer in a couple of minutes. We're going to move on to delivering mental health services. And so can students who go to the counseling center and are assessed as needing to be hospitalized refuse to be hospitalized? And if so, what options are available to institutions to ensure that those students receive continued care?
What do you think, Peter? It's an interesting question.
This is a very interesting question, Vic, and it has many, many parts to it. One of which is that you can't force people into care unless they've lost the ability to make decisions for themselves. Florida has a Baker Act, which is fairly aggressive, but most states, people have autonomy, the decision to choose to help themselves or not. It worked out for Kevin Costner in Dancing with Wolves, but I'll be honest with you, if you get shot in a Civil War battle in the leg, I strongly urge you to go to the doctor. Doesn't usually turn out as well as it does in that movie for Kevin Costner. And that can be very frustrating. And so what I tell institutions is don't let the frustration drive the decision making. Just because you would make a different decision for the student, you really have to compartmentalize this. And does the student present a risk to others on campus? So, for example, if the refusal to be hospitalized relates to a highly contagious and infectious disease, you can remove the student from campus and insist on some kind of care before return. If you have something a little more subtle, which this question might be asking, where the person is entirely at risk to themselves, you run into some pretty complicated questions about direct threat to self and the extent to which individuals can manage that. And the short answer, because I know time is of the essence, is that the Office for Civil Rights has given us blueprints for how you can manage self-care requirements. But there is a way to do it, and if it's not done properly, Office for Civil Rights and others might get squeamish that we're stepping on people's autonomy rights or their disability rights if that is presenting itself to us in the situation. And a lot of times, like the other part of this question too, Vic, and again, I'll shut up after this, is that sometimes people will not take us up on an offer for immediate medical intervention, but then may provide information to us that they have later sought such care. And then what we're doing is trying to follow up on whether they've actually done what they've said and whether it's helpful. And that raises a whole nother set of issues, is whether we can accept information that's coming to us sort of from another source about someone's wellness and readiness to return to school.
Right. So as you said before, Peter, this is the kind of question that could have its own series of webinars. But I think you're right. The short answer, if the student's at risk, you should do what you need to do to mitigate risk. A student who really might be an acute risk to self or others might be able to be hospitalized against their will in any case if you can, sort of get them into the system. If there's not that kind of acute level of risk, then, this is where I think Gary Pavella's advice that you say to the student, the consequences of this will be on you if you're not functioning, if you're creating a disruption, if there are other problems, then we're not going to necessarily use your mental health problem as a kind of mitigating factor in handling this. So, if you cooperate with us, then, we will consider your mental health problem. And of course, if you're providing the student with housing, if they're in your residence halls, you have more latitude to refuse to have a student to be allowed to live on campus than to attend school.
Yeah, and Vic, playing off that last point, we use this technique in employment sometimes. We sometimes call it progressive discipline, which is not a good moniker here, but the same idea is that, the idea that you're sort of in or out of school is sometimes a little too nuclear. And often by presenting students with some limitations that they'll have to live with if they're not choosing to follow a path we recommend, that can have as much effect as exercising the nuclear option, and sometimes even more effective. So
Yeah.
thought there.
Yep, makes sense.
Okay, so we're going to move on to our last couple of slides before we open it up to questions. So we have a lot of different kinds of questions here. We have examples of policies regarding students re-entering school after medical mental health leave. Is it advisable to require students who have taken a leave of absence for mental health reasons to submit medical documentation that they are ready to return to school full time, as we would with students who take leave for physical medical health issues? And then when a student comes back to campus after a brief hospitalization, can the Student Development Office strongly encourage or require counseling services as a way to increase support for the student and have some ongoing care while transitioning back to campus?
Well, I would say, I'll take a quick one. The answer is yes, you certainly can require conditions for return from leave in the same way as you would with a medical situation. You want to make sure the student is doing well enough in their condition to be able to, if it's a residential school, live away from home and function academically, and really has judgment about how to continue caring for themselves. And actually, I think I like that second question about, as we would do with leaves for physical or medical problem. I think it's a really useful exercise in relation to the Americans with Disabilities Act to think about, can you find a parallel to what you're asking a student to do on the mental health side on the physical health side? So if you look for documentation, if you would want to speak to the student to find out what their care plans are going forward, it's perfectly legitimate to do that, and I think advisable to do that on the mental health side. We just don't want to make separate demands or expectations, things that are sort of uniquely different in a stereotypical or potentially prejudiced way around the mental health side of things.
Yeah, Vic, I mean, I can echo this and sort of, do a little bit of a legal spin on it, but it's really the same answer. By the way, I mean, I think there are many good examples of policies reentering school, voluntary, involuntary leave, reentry policies. I'll leave it to Jed to decide which group of policies you might want to direct to people as promising policies, but I will say that Dr. Els had his hand on a number of institutions and left an imprint on some of these policies that I found personally very helpful, so that might be good. The documentation on return question and the counseling requirement, here's the thing that I've been picking up from OCR on this, is they want us to have clear, consistent, equitable across multiple disability policies. They want to see that they're applied clearly and consistently. And therefore, asking people to submit medical documentation, if that is not in the policy, would be problematic simply because it's not in the policy. A lot of people do that. It should be in the policy. It should be consistent for everyone if you use it. And OCR has also pushed the idea of doing individualized and holistic review so that we don't have cookie cutter approaches that everyone with a certain sort of thing, if they have a one letter, then they just get in. There should be intelligent design with each individual as to what their exit and reentry process should be. And this is my personal preference, is that I like clinical choices to be in the hands of clinicians. And, Vic and I have sort of had this conversation a lot. I think we're in agreement on it, but I don't like policies driving clinical decisions. I want to see clinicians have policies, but make good clinically based professional decisions. So the decision on how to integrate counseling into the return if someone needs to support, my instinct is to turn that back to the people that know best. I've heard a lot of counselors tell me that you require counseling, and I don't think it works. I think you can require an assessment, but not necessarily counseling. But I've heard other counselors who think it's within the professional realm that you can do that. And I like to let the Vics of the world make this decision. And I know it's tempting as the lawyers and the decision makers above to structure that decision making with sound policy. But sometimes the soundest policy is to remember that good, well-trained people with good intentions are really the core of our strength in these systems. And to deflect back to Vic, so this is, I want to give it to the Vics.
So this is where I like to say, not only do I have a number of friends who are lawyers like you, but since my wife is an attorney also, I feel like I can say that, it's, my sense is that we make a mistake in the student affairs and counseling clinician side when we say, oh, let's ask the lawyer what we should do. What you should find out is what you shouldn't or, probably shouldn't do. But the decisions about what space you have within the guardrails that, that the lawyers can define for you, that needs to be driven, as you say, by good clinical judgment and a desire to help the student.
Yeah. Vic, bringing this back to the beginning, I think sometimes we're so afraid of making a mistake or letting someone down that we paralyze our own good judgment. And, if there's one thing that I've learned from my experience losing Greg in the short term is no fear. I know there's some things that I can't change, fix, or alter the course of history. And I don't want that to be disabling. The worst thing we could do after Greg's passing is to go out and try to write a bunch of rules that ensure that no one will ever hurt themselves, when in fact, that never will work. What our best chance is to take a chance, to put the decision in the people who are best positioned to potentially make the right call, and do that without fear, but with a lot of trust and respect for professionalism. And I kind of heard that in the other question about confidentiality, because when people are pushing people to share information, they either don't know what they're doing or they're afraid. And I'd like people to go forward with this work. We deal with very frightful things, but it's our job not to be afraid, to have the courage.
Well, yeah. So, I've been speaking over the last couple of weeks with a number of different groups about this. And, I've been sharing something that's took me a long time to realize, which is that you actually can't work with high risk or suicidal patients until you kind of accept your helplessness. And, the fact that you can try to help and be there and, provide what knowledge and resources you have. But if you come in believing that you can control things or make things happen or have a particular outcome, you're going to be in big trouble, because, as you say, your anxiety will be overwhelming. And it really puts you in an impossible position. So, it leaves you with a kind of clinical humility, which is really important to be able to help people. You also have to recognize what you can't do, ironically. I mean, it is a paradox, but as you say, ultimately, ultimately you can't policy your way or protocol your way out of this. That said, I think you'll agree that the policies and legislation that's out there, FERPA, the ADA, the various laws, are really pretty good attempts to try to balance all of the considerations, and, really shouldn't get in people's way and shouldn't induce as much anxiety and fear as they seem to so often do. And it's also important to remind people that while this is a really complex, challenging population, we don't hear about the 95% of situations that have good outcomes, because those don't make it either to the newspaper or lawsuits or, anybody's attention. And it's really important not to lose sight of that.
Yeah. Hear, Vic.
Yeah. All right. I don't think we left Kyle with too much time here to.
No, you did not.
Okay.
No, we're gonna go ahead and end in the last 5 minutes with these last two questions. And as a reminder, we will have all of the slides and recording, as well as the closed captions, available for you to download at some point tomorrow. And we can continue this conversation and the question and the discussion. But I'm going to throw it back to you two on these last two, on liability ending for the clinician. Where does it end? When the institution has made an off-campus referral by someone at the college, and how far are we supposed to go when we have a student in crisis after hours with no on-campus services?
Yeah, and
well, so yeah, go ahead, Peter.
Yeah, I mean, real quick, Vic, and I'll just, I mean, there's a deep answer here, but there's a nice shallow one that actually works, which is when you're concerned about liability, if you're really only going to see cases when people get seriously injured or die, and where there's significant damages involved in some way. And these days, you can almost assume you're going to get sued, and you can assume that the process of lawsuit is likely to create a tremendous amount of accountability discussion about the decisions that were made. Occasionally, these things result in liability. A lot of times they result in fairly lengthy litigation, where sometimes the devil is looking at everything we've done. But what I've found consistently is that when clinicians are acting according to professional rules and standards, and they do so in good faith, it puts you in the best possible position to ultimately win the case, and also gives you good standing when you're asked to account for how things might have occurred. Similar answer with the off-camp or the late hour crisis issues is we are not 911, and we are not an instant emergency response system for everyone. And as long as the expectations are set and are reasonably followed, you generally are in a place that is at least legally defensible. But I will point out that our customers increasingly want to have services that are non-traditional. And again, any business that is smart realizes that customer pressure for services that aren't delivered will usually turn into legal battles sooner or later. And so we're all thinking about how to provide service delivery models that are more 24/7, 365, trying to anticipate not just today's generation, but what's coming around the corner.
And I'll just make one quick comment about the first in terms of off-campus referrals, which, more and more campuses are using case managers and people like that to follow up on referrals. This is a situation that's actually has come up in some lawsuits over the years around students who had serious mental health problems that arose or became evident at the end of the school year, for example, then either graduated or were away from school for the summer. And there was some kind of bad outcome. Again, I think the decision making, as we've been saying all along, ought to be driven by good clinical judgment. Sometimes there's a challenge because some of the counseling services in some schools actually shut down over the summertime, but you ought to have a capacity for somehow being able to follow up on a referral for a student who had severe depression or, was at the verge of a psychotic episode, who you sent home with, an agreement to seek support services over the summer locally. I think it would still, in a situation like that, it feels maybe, I don't know what the legal requirement is, but it feels like a kind of ethical requirement to try to find out, has that student settled into some kind of care, so that there's somebody locally who has some awareness that, that there was a serious problem.
Yeah, Vic, reasonable care usually follows the individual and the circumstance. And I think when you're in an acute or an imminent state, that's where more attention and more immediate attention is appropriate.
Yep.
But beyond that, I think the idea of, the Massachusetts court basically said this, that we don't have to have roving patrols in the hallways knocking on everybody's door. How are you doing? I hear you listening to some depressing music in there, a lot of Mahler, do you need to talk? And that would be, sorry for the Mahler fans out there, but that would be that would be an invasion of people's privacy and frankly drive people away from what we're trying to do.
Correct. Exactly right.
Okay, great. Well, we covered a lot of ground, and we will have a lot of follow-up to come in the next couple of days. But I want to thank you all for attending. Vic and Peter, thank you for sharing your expertise, and I want to wish all of you a happy Thanksgiving this week, and take care.
Thanks to everyone. Bye-bye.
Thank you. Thanks, Vic. Thanks, Kyle.
Thank you, Peter and Kyle.